Good morning, Miss Aina. I'm Marty Luke from Hafiz, Luke and Associate, and this is my partner, Mr. Hafiz.
Morning, Miss Aina.
Good morning, Mr. Hafiz and Mr. Marty. A pleasure to meet both of you.
Please, have a seat.
Thank you.
Miss Aina, according to the memo, you are about to purchase a bungalow, but there are several issues over the property, right? So, can you provide us with a further explanation on this?
There is one bungalow located at Kuala Terengganu. The vendor, Miss Sophia, wants to sell. The house fulfills my criteria and the price offered is great, I will say. The only thing that brings me to my concern is the issues revolving around the property.
Perhaps we can go through one by one so that everything is clear before we move on to SPA.
Sure. Is it normal for a property to be obtained before it can be transferred?
Yes, Miss Aina. We call it as a restriction in interest. Some of the property or land requires a consent from the authority before any dealings can be done over it. So this requirement will be clearly stated in the IDT issued document of title, which is similar to your case. And does the land we will be discussing consist of that restriction in interest?
Yes, Mr. Hafiz. Is it going to take a long time? I'm worried it might be within my teens. I'm keen to get everything done. Plus, do I need to submit the application or pay any cost at this stage?
We get your concern, Miss Aina. Normally the process will take few weeks and sometimes a little bit longer. But don't worry, we will keep you updated on that. The duty to get the consent from the land administrator is on the vendor, which is in our case Miss Sophia. What we will do now is to insert a condition precedent specifying Miss Sophia to get consent from the land administrator at her own cost and expense. Besides, we will also make sure the SPA reflects that the remaining payment is only due once we get the approval. At this point, you don't have to pay any cost, as it is the duty of Miss Sophia as a vendor to make the application to get consent.
Okay, that makes sense. As long as I do not have to pay the full amount until the approval is done.
Well, definitely, we will make sure that in the agreement. Now, based on the memo that we have received as well, your property that currently in question is under a private caveat. Is that correct, Miss Aina?
Oh yes, is it true?
How do you know that the property now is under a private caveat?
Actually, I went to the Pejabat Tanah Daerah Kuala Terengganu the other day to do the land search and found out that the said property is under caveat.
Did you bring a copy of the land search today with you, Miss Aina?
Yeah, I did. Here you go. But what is a caveat?
Caveat is an instrument designed to ensure that a third party who has interest over the property has protection against the owner selling it to another party.
Oh, I see.
Miss Aina, do you come across who lodged the private caveat over the property?
It's Sophia's exchange sibling.
So did Miss Sophia disclose whether she and her siblings are in good relationship or otherwise?
As far as I recall, she didn't mention anything about that. So what can we do at this point?
As far as the law is concerned, before any property can be transferred, whatever facts associated on that land, such as caveat, charge, and etc., must be free, meaning to say that the land must be clean and free from anything else before the land can be transferred. Miss Aina, I understand that you really want the property. Hence, there are two initiatives that will be try to solve this issue. Number one, we will write an official letter requesting Miss Sophia to consult her sibling to discharge their caveat over the said property. And number two, the second initiative will be, we will insert a removal of encumbrance clause, which imposes a duty to Miss Sophia as a vendor in this particular case to ensure that all encumbrances, we call it, to be removed before the completion period.
What if Sophia complies with the letter but her sister refused to do so due to a bad relationship? It will be less beneficial for me, right?
Miss Aina, it is the rule as any land or property before being transferred must be free from any encumbrances. Don't worry, if she does not want to comply, Miss Sophia still can apply for removal of caveat by registrar. We believe that her solicitor know what to do if the circumstances happen.
At this point, Miss Aina, is it clear?
Yes, definitely. I'm slowly feeling relief. Oh yeah, what about the fixture things? There are some furniture like cabinets, put in wardrobe and lighting that Sophia intends to remove.
We believe that you are expecting those to stay with your property, right?
Yes, I thought those things were included, especially since they are brought in. I have seen other properties where they stay.
Well, Miss Aina, it is not impossible to happen.
Have you got any chance to inspect the property, Miss Aina?
At the moment, I only got a chance to see it virtually from photos on the website and from Sophia's phone. But Sophia agreed to set a time so that I can come to inspect the property physically. She will revert to me back once she reschedules her time.
Sounds like a plan.
Yeah.
If that's the case, what we can do is that we can include the as is where is clause in the SPA.
Okay, what is the as is where is clause?
Well, basically, the clause will treat the property to be sold in its present state. And I believe that you have seen the property virtually and will be seeing the property physically soon. Hence, whatever you have seen must come with the property once the transaction is complete.
Means that the cabinet, the wardrobe and the lighting must be transferred to me with the house after I purchase it, right?
Exactly, Miss Aina.
But what if Sophia does not agree with the said clause? Can I still keep them?
I believe that those furniture that you have mentioned form part of the house and it has been attached to the land. It is in line with the definition of fixture itself. But our case is an exception where even though it is attached to the land, it does not mean it must be stayed. Depend on the agreement per se.
Yeah. The worst case scenario, we might not able to retain all of the furniture mentioned. But what is the furniture that you want to keep the most?
I really want the kitchen cabinets and wardrobes to stay. It is a part of what made me like the place.
What we can do here is to write a letter to Miss Sophia's solicitor expressing your intention to keep the cabinet and the wardrobe. I believe there's something that we can meet in the middle.
I hope she's open to negotiate about this furniture with us.
I'm sure she will.
I also noticed that there is an outstanding quick rent of 1,000 ringgit. Actually, whose responsibility is it to pay the said quick rent at this point? Is it me or Sophia?
Before I answer your question, Miss Aina, did Miss Sophia tell you why she has an outstanding quick rent amounting to 1,000 ringgit?
As far as I can recall, no. I asked and she responded by saying she overlooked me.
I see. Back to your question, Miss Aina. The concept is simple. Those who own the property will have to pay the expenses incurred over the property. So it is standard duty that will be included under any agreement precisely under amenities clause. So at this particular point, to make it practical and clear, we'll insert a clause under payment of outgoing specifying Miss Sophia's duty and responsibility to settle the outstanding quick rent amounting to 1,000 ringgit before the property can be transferred to you.
Besides, the payment receipt of the latest quick rent is needed when we want to do the transfer of title under Form 14A. Due to that, we will write a letter to her and her solicitor to ensure this matter is settled before the transfer takes place.
Really glad to hear that. Speaking about the payment as well, Sophia stated that the deposit of 20% should be paid to her directly after we sign a sales and purchase agreement, in which I totally disagree with her as it is open to any unwanted situation to occur.
Did you disclose your intention to give the deposit money to the stakeholder?
Yes, I did.
Oh, what's her reaction, Miss Aina?
She raised her voice and insisted that the deposit should be transferred to her directly, but I did not argue as we were in the public. Hence, I kept silent and changed the topic of discussion.
Completely understand, Miss Aina. We respect your move to not to argue in the public.
Thank you. I really want the deposit to be put in the stakeholder account so that it can protect our interests and be much safer. What can we do?
Well, that's a good point, Miss Aina. Well, we are unsure on Miss Sophia's intention to have the deposit to be transferred to her directly instead of being kept by the stakeholder. Now, what we can do now is to ask Miss Sophia's solicitor to convince her concerning the 20% deposit, which is better to be put in the stakeholder's account, since her reaction during the first meeting was not leaning towards that. And secondly, in the SPA, we will insert a condition stating the deposit which should be paid by Ms. Aina's solicitor as a stakeholder after the SPA is signed.
I'm really fine with that, but I'm concerned if Sophia won't agree with this.
Totally understandable, Miss Aina. Afraid not, lawyers are great at convincing their clients. I believe that Miss Sophia could not see the benefit if the deposit money was kept in the stakeholder's account when she met you during the first meeting. Maybe her stance might be different after this.
Thank you. So much relief after I disclosed everything and found out that everything can be settled.
We are really happy to hear that, Ms. Aina.
Alright, so to recap, on the restriction in interest, we will include a provision clearly indicating that Miss Sophia needs to get the consent from the land administrator at her own cost, and the payment balance is due only once she's clear. Secondly, on the caveat, we will send a letter to Miss Sophia reminding her to ensure it is removed before the transfer. And thirdly, the fixture will be negotiated and clearly listed in the SPA. Fourthly, the quit rent will be paid by Miss Sophia before transfer takes place, and the deposit will be handled by Miss Sophia's solicitor as a stakeholder. Sounds good?
Yeah, that sounds perfect to me.
Ms. Aina, before you forget, do you mind sharing Ms. Sophia's contact details? Perhaps we can talk to her and also her solicitors.
Oh yeah, I have. Her name is Sophia Binti Ismail. The IC number is 8303067890, and the phone number is 018-754-3201.
Appreciate it, Ms. Aina. Now, we will try to contact and negotiate with Ms. Sophia's end, and based on all of this, so we will proceed to draft the SPA. Once it is ready, we will set a date and time to go through the agreement once again.
Okay, sure, Mr. Hafiz.
Is there anything else, Miss Aina?
No, that's everything.
Well, that concludes our session then. Thank you so much for your time. If there's anything else, we'll contact you as soon as possible.
Thank you so much for both of you as well. I look forward to getting this started. Thank you.
Sure, we'll take care of this, Ms. Aina.
Thank you.
Have a good day. Thank you.